Hi, I'm Anna Denton-Jones, and in this video I'm going to be explaining a little bit about settlement agreements from the employee's perspective and what my role is when I'm looking at them for somebody. Now, a settlement agreement can be entered into in any circumstance that somebody is leaving their employer. So they obviously cover a whole range of things, and this advice is obviously going to be quite generic, and you're going to need to take specific advice on your own circumstances. So they can be used where the employees resign, they can be used where the employer has given notice to the employee, they can be used in circumstances where there is no notice yet served and the parties effectively choose a termination date when the employment will come to an end. The reason why the employer wants a settlement agreement is to have a real line in the sand. They want to know that there's no comeback from an employee. So they want to know that once they've signed the document, once they've paid the employee what's agreed, once all the provisions in the settlement agreement have been dealt with, that there won't be any further legal action by that employee. So there won't be any employment tribunal claims, there won't be any court claims, there won't be grievances raised, there won't be subject access requests for data protection, all of those sorts of things. So you need to also view it as a real line in the sand. Settlement agreements are covered by some legislation that sets out that certain key ingredients need to be dealt with in those documents, including the fact that you have to take legal advice from a legal advisor. Their role is obviously to explain what the document means and to talk it through with the person, but there are other clauses that have to go in the documents as well, and any settlement agreement will have those long lists of legislation and bits and pieces in them that are there because the legislation says it has to be. Because the documents are drafted by the employer, they do tend to be quite one-sided. And my job when I'm acting for you as an employee is to try and rebalance that a little bit and look at some of the areas perhaps where the employer is neglecting things that are important to you, and to make sure that your interests are represented in that document, as well as the employer getting that certainty that they want. I'm going to be looking at three main things. Firstly, documents tend to be quite similar, variations on a theme. I'm also going to be looking to see if there's anything that's unusual in that document that I haven't seen before, or that wouldn't be normal in your circumstance. I'm clearly going to be worrying about what you're being paid. I need to understand your current pay and benefits, whether that's pension, holidays, bonus, commission, cars, shares, all sorts of things that employees have, to make sure that your employer is paying you everything that's due to you in that document. And I'm also going to want to understand the background to your situation to assess whether the employer is paying you sufficiently under the agreement to compensate you for what's happened, and to make sure that you're not being shortchanged effectively. So there may be some negotiation that's necessary around what the employer is offering, and that's one of my primary roles. But I'm also going to be picking up on things that the employer's probably forgotten a little bit about. It might be a reference, it might be what you were allowed to say to third parties, because you need to be able to talk to future employers about why you left. I'm going to be focusing a great deal on the tax implications of what the employer is doing. We've had some rather big changes to tax legislation recently, and sometimes I see employers proposing to pay sums tax-free that really they can't. And there's often something called a tax indemnity in these documents, where you are promising that if the taxman goes after the employer saying that they haven't paid the right amount of tax, then the employer wants to be able to come after you. So obviously it's really important that we narrow that down as much as possible. I'm going to be worried about whether the employer is looking after you adequately with things like support, outplacement support after after you've left. Things like property that you've got to return, that you may be allowed to keep, what the arrangements are around that. The documents themselves don't become binding until everybody's signed it. So that's an advantage in that we know the employer wants it signed. So you're a bit of a loose cannon until we get it signed. So that can help in a negotiation. But you're going to have to be careful to keep the negotiations confidential. You may be able to confide in your nearest and dearest, subject to them keeping it confidential as well. But you need to be very careful about what you're saying to colleagues, to other family members, to friends, and particularly not saying things on Facebook. So we need to agree what it is you are going to tell people. And you may have duties to your employer right up until you leave. So you might have to do a handover. There might be cooperation clauses where you have to assist your employer with something after you leave. And we need to check your contract of employment because you're likely to have duties of confidentiality, and there may even be further restrictions on what you can do after you leave. So those clauses are typically called restrictive covenants, may affect who you can go and work for, and what you can do after you've gone. So we definitely need to focus on that. So dig out your contract or staff handbook, wherever those things are. Other things that sometimes come up in settlement agreements will be around assistance after you've gone. So an employer might well want you to come back and assist them, for example, if they had a court case against them, and I'd want to make sure they were going to pay you if that happened. I've already mentioned some of the gagging clauses that we typically see around confidentiality and what you are and aren't allowed to say after you leave. We may want to make sure that any provisions in relation to not making derogatory comments is a two-way street, so the employer can't make negative comments about you as well. And then there's going to be a real focus on that line in the sand that I talked about earlier, and making sure that there's usually a long list of every claim the employer can think of in the kitchen sink chucked into these documents. I will be talking to you about the main claims that you're going to be giving up. So claims for breach of contract. So that's why it's important that we make sure the document reflects you being paid everything you due under your contract. If you've got the right to claim unfair dismissal, you may well be giving that up. So again, we want to make sure there's sufficient compensation to compensate you for that. If you have potential claims under the discrimination legislation on grounds of a protected characteristic, again, we're going to need to make sure you're being compensated sufficiently for injury to feelings or losses you may have suffered as a result of that. And we're going to need to make sure that any claims that you might have in relation to back pay or commission and bonus and those sorts of things are sorted out in the agreement as well. I'm also going to be making sure that certain things are carved out. So personal injury claims that you're not currently aware of, you shouldn't be giving those up in the document. So for example, if you've had a very stressful situation or you've hurt yourself recently, you know about that, you're unlikely to be able to bring a claim in respect of that. But if there was, I don't know, asbestos in the building and you became ill in the future, you ought to be able to still bring a claim in respect of that. We also tend to carve out anything to do with your pension pot, maybe statutory maternity pay calculations if that's applicable to you, other bits and pieces. You still need to be able to obviously enforce this document as a contract itself. So if the employer didn't pay you, that you can bring a claim in respect of that. You may be asked to give certain promises in the document. They tend to be called warranties. So you may be warranting that you haven't done something that would justify your employer dismissing you, that you haven't already got another job lined up because your employer doesn't want to pay you a big chunk of money if you're going to walk straight away into something else, that you're not aware of any personal injuries and that you haven't gone to ACAS for early conciliation or breached the confidentiality provisions, etc. already. Your employer may back those sorts of clauses up with what I call the insurance policy clause, where they say if you do those things, they'll come after you for the money back. Often there's something called an entire agreement provision in the settlement agreement, where essentially we're saying everything in the document is it. So if you've been promised other things that are not in that paperwork, then we'd need to make sure they were included, because the employer wouldn't have to honour those promises otherwise. It is normal for the employer to pay the employee's legal fees, but it does tend to be a bit of a battleground. Typically, what the employer will be offering by way of contribution towards legal fees will be just that, a contribution, and it won't be enough. So we tend to have to negotiate around that, particularly if the employer ends up asking you to sign the document more than once. Obviously, that can put your legal fees up as well. I've just mentioned signing the document more than once. If there's a big gap between the agreement and when you're actually leaving, it's not unusual for the employer to ask you to sign the document twice, because there is a potential that claims could obviously arise between now, when we agree the document, and when you actually leave. So the second version of the document is promising you're not going to bring any claims in respect of those new things. Obviously, that does tend to put legal fees up, because there's lots of paperwork to be done. But it isn't unusual these days for employers to be asking employees to sign twice. That's probably enough for me for now. I look forward to speaking to you about your settlement agreement.